Here we are, bringing heaven down to earth at this beautiful beachfront resort. This is the way we do when we're helping people get their lives back, get their children back. What's going on?
Can I go down in the ocean?
Yeah, buddy, that's what we're here for.
Guys, please help bring heaven down to earth, or it will be Hades, when my generation grows up.
So that's my little man in training. I hope we all got a little man, a little woman in training. If you wish to see how to live like this, how to help people out at court, how to get people's rights back, and live like heaven on earth, stick around. We're gonna show you.
Ha ha ha. I'm just kidding, because we don't have any rights anymore. Nobody can make money trying to help people uphold their rights in a courtroom these days because we don't have the rule of law anymore. It is gone. I really, really hope that we get back to it one day because I have seen the rule of law. I've seen courts uphold things like your right to remain silent. I've also seen them violate it. I've seen courts uphold your right to free speech. I've also seen them violate it. I have seen courts uphold your right to know the nature of the wrong and the cause of the accusation against you, and not just the nature of the charge. I've also seen them violate it. And I got to apologize to everybody who is a regular viewer here on Just Conspiracy, who knows inside of their heart and soul that the only way to change these things, the only way to make our society better is by the return of the rule of law, not just for the elites, not just for people like Donald Trump, but for everybody in society. I wish to apologize to you and say I'm sorry for falling off back in October, November. Back then I was talking with you about what had happened with Joni when we predicted that the courts were going to violate her rights and throw her in jail to steal all of her property. 2 days before they did it, we filed with the federal court to inform them of that, and then they threw Joni in jail and violated her rights to steal all of her family's money, all of their property. And her father, Baba, passed away last month. Heaven rest his soul. Heaven rest his soul. He couldn't stay here with us long enough to find justice. And that's a really, really sad day that I don't wish for any other American to have to experience. Henry himself would not wish for any other American to have to experience that. So instead of breaking down everything that came from court and writing the mandamus with you here on Just Conspiracy, I felt like I just had to write it on my own because of the time restraints to getting it out. But they've answered, and it's scary. Stick around till the end because I'm going to read about it. With that being said, we don't have any law anymore. That was basically their answer, spoiler alert. But you don't need me to tell you that because you live in this society. You watch TV. You watch YouTube. You already know Trump has been indicted and arrested. And if they can arrest and indict and bring no law to a former president of the United States, why do you believe you're safe?
You're a Harvard professor, and you're basically saying the rule of law does not exist here. You are basically saying, go ahead.
It does not exist for Donald Trump. In my book, Get Trump, I prove that the rule of law has an exemption. There is the rule for everybody else, and there's the rule for Donald Trump, his lawyers, his associates, his family. This from a man who voted against Trump and intends to vote him against him again.
Let's talk about a change of venue. Let's talk about the statute of limitations, prosecutorial abuse, selective prosecution. You know, Greg, I look at all these issues. To me, it's all slam dunk. All of these things should throw this case out immediately, but yet that doesn't appear to be happening.
Yeah, but you've identified all the things that lead me to now believe that we don't have a justice system anymore. We only have a legal system, and it appears corrupted. And Americans recognize this. They've lost faith in our legal system. And there's a reason why Trump's polling numbers have suddenly shot up. His campaign coffers are now filled with millions of dollars over the last 3 days because Americans are very smart people, and they see what's going on. This is a persecution disguised as a prosecution. They recognize that this is a feeble zombie case resurrected from the dead and is purely politically motivated. A whopping 76% in the latest CNN poll say this is politically motivated, and they're right, it
Alan
is.
Dershowitz talks about, oh, no, it's not that there's no rule of law in America anymore, just not for Trump or any of Trump's friends. But he's talking about the same rule of law that they talk about on all the other channels where nobody's supposed to be above the law. The law's supposed to apply to us all equally, which means that if the rule of law doesn't apply to Trump and his friends, his people, then it doesn't apply to us all equally. Therefore, I deduce the logic that there is no rule of law. Absolutely no rule of law. I enjoyed the other commentator when he said, we have a justice system without justice. It's only legal. We have a legal system. It doesn't have any justice, which is kind of like saying it doesn't have any law. Imagine that. Because the law is just. That's where the word juris comes from. Jurisdiction, jurisprudence. Because it's just. And it's right. And if they're going to break the law against the former president of the United States, what makes you think that they're not going to break the law against you? And that law can only be broken in our society because our civil value system has broken down and allowed these things to happen. This is why 5 years ago, when I was talking about Henry, when I was talking about Baba and the Ramo family losing their property, the courts taking from them and giving to somebody else without law or justice or rights, I told you back then, 5 years ago, if we don't stop this now, it's going to spread. And eventually, it'll come for you. It'll come for you. Now it's gotten an ex-president of the United States. How far are you going to let it go? When are we, as a society, going to talk about these things and change our values with each other and how we treat each other? Because this is really, really scary stuff. And we have to do it as individuals. We have to talk with each other about it. We have to share this information around, because YouTube's not going to help us. Google's not going to help us. Algorithms won't help us. They wish for this idea to stay out of the psyche of people's minds as much as they can possibly keep it that way. That's why they have things like censorship. That's why they have things like censorship. And that's not even a really big and important case, because Trump's case is not going on yet. It's not even expected to be heard again until next December. Or this December, coming up in almost a year. But a case that kind of relates to that, that's going on right now, is the Proud Boys. And we're going to talk about the Proud Boys because there are some insane things going on with this case that everybody should be worried about. Everybody should be concerned about. And it starts with what the FBI hid in Jenks material away from the defense counsel.
During cross-examination, Agent Nicole acknowledged that she alone compiled those records. Nobody else helped her with that. She did it herself. She testified that in cross-examination that those messages constituted everything, a total production. All her statements from Link, that she's complying with the rules. And as we know, the discovery tells us that it is a must, right? They must produce it. We also know that discovery violations, when they hide things, according to the Brady rules, they're pretty much material. They have to follow those because those are constitutional obligations. Oh man. So if they make some pretty serious discovery violations, that might result in a dismissal of a case. Hopefully that doesn't happen for those prosecutors. Now, they say this is the defense writing. However, those 25 rows, no, not so fast. A close examination of Agent Nicole's sheet revealed over 1,000 hidden Excel rows of messages. Huh. You're kidding me. That's weird. Why would there be 1,000 hidden rows of messages that were hidden of Excel rows? I don't know. Strange. Miller was thus examined as to whether she had withheld from prosecutors those link messages. The defense says we examined her to ask about these messages that were very conveniently hidden. They've got questions about whether the messages contain any of the following. All right, so Nicole, so it sounds like you've got a lot of these messages that are missing. Do any of those messages involve a conspiracy charge about the Proud Boys case, in particular, whether it was justified or not? Do the facts support a conspiracy charge? Did your messages talk about that? We're going to find out. Nicole, did your messages talk about a Telegram user, somebody called Aaron of the Bloody East, who was involved in, quote, planning chats? Who would that be? That wouldn't be like a federal agent who was involved in, quote, planning chats, right? That couldn't be somebody called Aaron of the Bloody East, certainly. You wouldn't have hidden those messages, would you? You wouldn't have hidden messages about inaccurate FBI informant-related information about whether that should be disclosed to the defense, which would be a Brady problem. You weren't talking about inaccurate FBI information in your messages, were you? On your Slack message, FBI secret Slack channel, were you? And Miller said, no, I wasn't answering, no. She's like, him. So they're just talking about it. They could, again, you're allowed to plan to show up and protest places. You're allowed to have clubs and free assembly with other people. That's allowed in America. You are not supposed to be infiltrated by rotten FBI agents. But they did it anyways. So he says, okay, somebody says, so will this get us over the hurdle of the conspiracy charge? You see how rotten these people are? They know they don't have anything to charge these people with conspiracy with, and so they're begging for it. They're jumping into their chats, whatever the plan is, right? They could be planning to go to a picnic there on the Capitol lawn, and they're going to say, perfect, we got those white supremacists now. Enrique Tarrio's not even white. So this is nuts. And they know that their case is weak, but they're saying, well, will this get us over the hurdle? Because if not, we got to manufacture something else. And they're literally chatting about it. That's how non-obvious the crime is. The crime of the century, so-called, is so non-obvious, they don't even have enough to get over the hurdle. And the FBI agent lied about it. Did you talk about any of that? No, we didn't. You did. And the materials you disclosed hid it. So then another message says, okay, so long as we can actually go after them with conspiracy, and check this out, and not make a fool of ourselves. See that? Fortunately, this was uncovered. Thankfully, it was. Disgusting that it had to be uncovered. And hopefully there's some recourse for it, but we'll see what the judge does about it. So they are talking about being worried about not making a fool of themselves because the conspiracy charge is such a joke. No conversation, no admission about whether there was an agent and a request to Agent Miller to go into a CHS report, look at this, and edit out that the agent was present. So retroactively go back into a confidential human source report and edit out that the agent was present. You see this from this email address, row 11159. And boy, look at all these thousands of messages. So she just thought she did an export, huh? This is B121. Oh no, that's 8122-645-6485. Look at all these rows, man. Okay. So we're now at 11159. N. Miller sends a message in the FBI Slack channel, their link system. It says, you need to go into that confidential human source report you just put out and edit out that I was present. See that? Nicole Miller says, go into the report that you wrote, delete out that I was present. That's what the defense attorney got. They didn't make this row up. This row came out from the FBI, apparently from Nicole Miller. She said under oath that she's the only person who put it in there. Why does she need to edit that out? And why is the FBI so open and brazen that they're sending this stuff out? I mean, unless she wasn't there. Maybe she wasn't there, right? If she actually wasn't there and they put her in there, well, that's obviously wrong. That's factually inaccurate. But I doubt that's the case. Just saying. Now, we also have another question that Nicole presumably hid. The 1776 returns document, they asked her questions about it. There were questions about whether that document could, quote, solidify the conspiracy charge. So a message either to or from Nicole Miller at the FBI sends the 1776 returns document. Okay, so this document that the Proud Boys are probably passing around in their Telegram group or whatever channels they're using. So they say 1776 returns, something like, we're going to take our country back. We're going to get this nation back on the right path or something like that. And these whack job psychopath FBI agents who don't even know how to use Microsoft Office are saying, this might solidify the conspiracy charge, looking for anything, because they're sharing this document. But they say, but the Capitol building wasn't listed nor circled for, quote, the occupation. That's weird. They say, would that be an issue? Well, yeah. I mean, if you're trying to say that they were creating a conspiracy to insurrect the Capitol and they don't have any preparatory material for that, yeah, that's an issue. But why did you delete that, Nicole? Why didn't you just include all of this honestly and disclose that in your Jenks material to the defense after you testified? Why might that be? Now, the defense continues. They say, Nicole, the FBI agent, her communications with another agent are also included in these messages. We can see them. And it also states that the FBI boss assigned her 338 items of evidence I have to destroy. Nicole Miller's communication has a conversation with another agent who states that her boss said destroy 338 items of evidence. I don't know what that evidence might be. What could it be? The defense says that from the hidden rows in Miller's link spreadsheet, FBI Nicole, it is apparent that the defense has not received all of her Jenks statements in these relevant communications. Right? We talked about a lot of things, and she didn't give us the materials that she's obligated to give us under the federal rules.
That was a motion made by the defense counsel of one of the defendants, Defendant Real, I believe. And it was made a couple of weeks ago. It was made before the next thing that we're going to talk about. And in there were hidden messages. Remember that. Hidden messages, hidden text about conspiracy and conspiracy charges, hurdles of those conspiracy charges. There were messages about destroying evidence, 338 pieces to be exact. There were messages about taking somebody's name off of a document for some reason or another. Very, very questionable things. Very questionable things that the FBI is doing. Well, obviously that motion to dismiss was not granted because they kept going on with trial, and then the defense gets to the point where they're going to put on their defense. They're going to say, hey, this is why our people are innocent, and you shouldn't find them guilty. So they're going to call a witness. Before they can do that, though, the government informs the defense counsel that that witness they're about to call happened to be a confidential human source that they never disclosed to the defense team until we're in the middle of trial. Until we are in the middle of trial. So let's hear the motion on that one.
Zachary Real, his defense attorney, Carmen Hernandez, filed a motion to dismiss, and it is a doozy. Here's what it says. Filed March 22nd, 3 pages long, out of the District of Columbia, United States of America versus Zachary Real. And here is the title. Defendant's motion to compel the disclosure of all FBI interview reports and all DOJ memos relating, listen, to the recording and the reporting of the defense team. What? Compel disclosure of all FBI interview reports and DOJ memos relating to the recording and the reporting of the defense team? Defendant Zachary Real, through counsel and pursuant to the Constitution, respectfully removes this court for an order compelling the government to disclose to the defense all reports, including FBI 302 reports. Mr. Real and the defendants are herewith preparing a separate motion to dismiss the indictment, or in the alternative for an evidentiary hearing, raising serious and substantiated allegations of government misconduct surrounding the surreptitious invasion and interference of the defense team by the government through a confidential human source at the government's behest. The instant motion is based on a disclosure made to the defense counsel today, March 22nd, 2023, at the end of the court proceedings, wherein the government stated that one of the witnesses who was disclosed to the United States and to the court in December 2022, who was scheduled to appear in the defense case the following day, has been serving as a confidential human source since April 2021 through at least January 2023. Holy moly. Okay, so the defense disclosed witnesses saying we're going to use our witnesses for trial. Coming up, what we're in the middle of right now. The disclosures were made in December. That witness list was on the name in December. Seems to me like the government got wind of that, terminated the confidential human source date after that disclosure, ended it, and that means that throughout the entirety of this pending case, there is theoretically this confidential human source who is also a defense witness. Now, we're not done. During this period of time, the confidential human source has been in contact via telephone, via text messaging, and other electronic means, somebody working with the FBI, with one or more of the counsel for the defense and at least one defendant. The FBI, according to the defense, all of them, the FBI has a confidential human source who was communicating with the defense lawyers and the defendants themselves. It's earth-shattering if this is true. During this period of time, the confidential human source, who's on a witness list, also participated in prayer meetings with members of one or more of the defendants' families. That's what your FBI is doing. The confidential human source also engaged in discussions with one of the defendants' family members about replacing one of the defense counsel. The above may not include all communications that have been initiated or engaged in by the confidential human source. The allegations about the existence of yet one more previously undisclosed CHS, after various other alleged full and complete disclosures of all the CHSs in this case, demonstrate that there are reasons to doubt the veracity of the government's explanation and justification for withholding information about the CHSs who have been involved in this case. Moreover, the government disclosed this information for the first time on the day before the witness was scheduled to appear. Accordingly, Mr. Real and other defendants in this instant case respectfully request
The defense team doesn't find out about the confidential human source until they're about to call him in the trial. That confidential human source was talking to the families, going to prayer groups with them, was in constant communication with at least one of the defendants, maybe more. Text, phone calls, sat in, helped give advice on legal strategies, whether they should switch up their attorney or not. That sounds pretty crazy. And the fact that the government knew that they were going to call this witness and did not disclose to them, did not give them any type of notice before trial that this witness happened to be a confidential human source who got paid by the government to spy on people. That should have everything really, really thrown out, considering that you have more FBI informants in this case than you have defendants. There are more FBI informants interacting with the defendants than you have defendants. That's absolutely insane. If there was any law around, obviously, those facts should really throw out the case all on their own, because the government is not performing their duty, the prosecution is not performing their duty to disclose and give all exculpatory evidence to the defense. The government didn't do it, the FBI didn't do it, the prosecution didn't do it, and then when you're at court, the judicial officer may or may not decide to do it. I don't know. But I can't believe that people are still respectfully asking from the courts to do whatever. I'm respectfully asking the court to uphold my rights, even though you guys keep running over them every single time I come in here. But I'm still going to have to respectfully ask. This is how government takes all of your rights if you don't do anything about it. And the court of public opinion is incredibly powerful. You don't have to go down and physically take over the courthouse with guns. The court of public opinion is just that powerful. But what makes me really, really worried is when the courts start closing themselves away from the media, away from the people who are supposed to press them and make sure that they are upholding and following law. So the media put in a motion to get in on this, CHS who wasn't revealed to the defense team. Because apparently they've been locked out of the court before.
after the crime is over, they're still trying to snoop on what the defense is doing? Explosive motion, explosive consequences, if true, you would think. So the media wanted to be a part of this, and here's what they said. Holy moly. They filed this 6-page. They said, Judge, can we please be here for this one? The March 23rd memo, look at all these people. CBS, Wall Street Journal, Huffington Post, LA Times, NPR, New York Times. We respectfully move the court to ensure the motions are open to the press and the public. The court has previously excluded members of the media from proceedings. And we filed this motion now. We want to assert our First Amendment to get in here. Capitol riot was important. All the defendants were important. The March 23rd hearing, they say, Judge, yesterday, the court converted today's proceedings, the ones that were supposed to go on today, into a motions hearing. The change was prompted by the motion that we just read, saying that there are CHSs embedded in the defense team. According to the motions, the defense learned that near the end of yesterday's trial proceedings. They were going to call a witness. They didn't realize it was a CHS. Uh-oh. And the court has, without prior notice, previously sealed hearings and excluded the press. Why would they do that? This court did not indicate previously that the November 14th hearing would be closed because this judge doesn't want anybody to see all of this stuff. And they say, we are the press. We have a right to come in here and be a part of this, so please let us in. Give us access on March 23rd. Sincerely, your friends in the press, Charles Tobin.
I don't care which side of the political aisle you are on, if you are on the right or you are on the left, or the way you're looking at it, if you are on the right or if you are on the left. I don't care which side. You know, the right wing and the left wing go the same bird. But the body of the bird should be very, very strict, that we cannot let courts get away with not allowing the press in on criminal trials at all. That is absolutely insane. They call that a star chamber. It's a really, really bad court. They had them in England several hundred years ago. There was a revolution. People died. They got rid of that court. Let's not do that again. Please. Why don't we stop this before it gets to that point? Because that's where it's headed. That is where it's headed. I don't care if you are a Democrat, a Republican, liberal, conservative. I don't care. You do not want a civil war in this country. I promise you that. And you're going to get one if the people cannot come together and make sure that law is upheld. It's the only other option, really. People will not have their rights stomped on forever. It just won't happen. It won't happen. And with that being said, and hopefully everybody understands how dangerous having star chambers are, because we've talked about them for a long time on this channel. We've talked about them for a long time. Now they're doing it to people in national cases. This is what's really, really scary, because it's getting normalized. Just like them talking about gagging Trump. I'm sure that they knew they weren't going to actually gag Trump. They just wish for you to believe that that's normal. Think about that for a minute. How much sense does it make to allow the courts to gag a defendant? Typically, prosecutors wish for the defendant to go out there and say everything they want to say. That's why you have the right to remain silent. A right cannot be your right if they force it upon you, or if they can force it upon you at any point in time, because that takes away your right to exercise a right when you wish. But let's see how the government responded now that the media is there to watch them. Let's see how the government responds to the defense counsel making these claims.
The defense made their own volitional basis for engaging with these people. We never asked them to do this stuff. They did it on their own. And a prosecutor has no duties to disclose this stuff until a certain point anyways. And the FBI that they are supporting through this person here named Christina Spindel is going to give us some more details on this. They submitted this as a declaration. They write, I, Christina Spindel, FBI agent, have personal knowledge of the facts and will testify to them if called to do so. Does it say that she's a CHS in there? I'm guessing not. Some of the information that the CHS provided prior to being officially opened as a CHS did relate to 2 defendants in this matter. That was provided to the FBI in 2019 and did not pertain to their status as defendants in this matter. So these guys had, these Proud Boys were so scrutinized, they had them all the way back in 2019, 2 of these defendants. 2019. So if they had all of these CHSs, if they had all of this information going back to 2019, they had Kenny Lizardo, we suspect is a CHS, who was picking up Enrique Tarrio from jail. They had this woman, this girl, whoever she is, who is also working with them, providing information about them all the way back to 2019, and the FBI couldn't stop them from almost insurrecting America? Are you serious right now? What if the CHS didn't tell them? What if the CHS didn't tell them and the defense just called this person as a witness? They say this confidential source was never tasked to communicate with their lawyers or to gather any information, so they're trying to say, we didn't do it, she did it. The FBI was never provided information about any contact or communications that the CHS may have had with the defendants or their lawyers, nor was the FBI provided any specific information about any contact the CHS had with family members or the defendants other than their generalized knowledge about assisting in fundraising efforts and petitioning against the conditions of their confinement. Forgive me if I don't believe you for a minute, not even a minute. Generalized knowledge about random things. We never got access to their defense strategy. We never got access to what they were talking about with their lawyers or their pastors or their family members in the confines of their home. No, just generalized knowledge. Nobody believes you at the FBI anymore. Nobody. I've spoken with the agents to whom this CHS was assigned. I've reviewed the official file. My review of the file and my discussion with law enforcement confirm that the CHS was never tasked with obtaining information from the defendants or their counsel, nor did they receive any such information regarding the defendants and their counsel. Now, the judge is probably going to use that to just paper over this whole thing. Oh, well, they never got anything bad from this person.
Can you believe the government's response? Hey, we didn't make the confidential human source interact with the defense team. They did that all on their own. That's outside of anything we have control over. Yeah, but you want to know what you do have control over? You have the control to tell them that the person they're thinking about calling as a witness is a confidential human source for the FBI. See, you have that kind of control as the prosecution and as the government and as the FBI. They bring in an agent, Agent Spindle. See what I mean about names? Agent Spin, who makes a declaration. And why is that important? Because I always talk about common law on this channel. I'm like, a affidavit is not as strong as a declaration. I've talked about it before. They're trying to look like they're performing law. And the other thing that's going on is they know that none of the defendants are going to speak for themselves until maybe the end of trial, because that's how it always goes. So they know that if they place this declaration upon the record, nobody can rebut it. Because you'd have to have one of those defendants talking for that, which is what the prosecution is praying for. Nobody outside of the defendants and the FBI have any first-hand knowledge of what actually happened. That's why nobody else can testify. That's why this declaration from Agent Spin, because we're going to spin the story on them, holds serious weight in a court of law, which they are trying to appear to be. They're trying to appear to be. And what does the agent testify to? Oh, we didn't tell them to communicate with the families or the defendants or their legal counsel. We didn't tell them to do any of that. Really? What were you paying them for? Why were they a confidential human source for you? Just please explain that. That's like saying, well, Russia, I know that you caught one of our spies over there, but hey, look, take my word for it. We promise we didn't send that spy over there to give us back information about you, Russia. You can't hold them accountable. You're the one who didn't know that they were a spy and chose to do business with them, Russia. That's the logic of this. And the jury is not allowed to see any of these things. The jury does not know about the motion. They don't know anything about what's going on outside of what the court will allow them to see. And the court has already withheld what I would believe to be very pertinent and exculpatory evidence. That's just my opinion as a layman, as somebody who believes in natural rights. It's funny, but it's sad. And let's see what the judicial officer does. What do you think the judicial officer is going to do? And let me just warn you before we get into this little section. See, they won't allow cameras in. They won't allow microphones in. The press, to my understanding, has to go to like a press room, and they can only tweet this information out. And kind of like the last video, you look at the three... As I was saying, federal courts don't allow cameras, they don't allow recording devices, and because of that, Roger Parloff is down tweeting the entire case. Look at the likes. He has 40 or 50 likes. If you're on Twitter, I would strongly suggest that you follow and pay attention to what's going on. These tweets that are coming out by Roger Parloff, because we have to value people who stand up for our rights more. We have to value people who go and try and report on the loss of our rights more. If we do not value these things, we will lose them, and they're basically already gone. They are basically already gone. I would do it except for the fact I can't go on social media platforms because it's too extreme, it's too crazy to sit here and talk about how we should have a court of law and respect people's rights. So, the only way we're really getting the information out is because Roger Parloff is down there tweeting about it, and my man Robert is going to tell us about it with his own interpretation and views.
Smith is not making that argument. Their attorney, because, well, the judge would never allow that argument in the first place. He's not even allowing any conversation about the CHSs. He excludes it, even though it's a critical part of your defense. Of course. Now, why is the judge doing this? Well, the judge is pretty much dug in at this point. We're in the middle of a trial. He definitely does not want this train to come off the tracks. And if it does, well, then he just kept 5 people who have been spied on by the FBI with FBI informants in attorney meetings, has been, these people have been housed in subpar conditions. One of them at least has no violent crimes at all. He's been held in custody. This seditious conspiracy thing would evaporate overnight if this train goes off the track. And he's not going to allow that to happen. So we were asking ourselves, and I'm honestly a little bit surprised about this today. I thought that we would get some conversation about the FBI, some part of it. Nothing. Not even a little bit. He excludes the whole thing. Let's carry on. The judge rationalizes this. He says, you know why? This is not like the other informants that we've discussed. He says people who were CHS's informants on J6. Says this person's relationship did not formalize until after January 6th, and even informal relationship before January 6th is irrelevant. I don't care. And we're asking ourselves, what? I mean, they're trying to show that there was this big intentional plan. A conspiracy is like 2 or more people conspiring to do a thing, And if all of these CHSs were part of this Proud Boy conspiracy of seditious insurrection, seditious conspiracy, why is that not appropriate? And why is her not messaging that to the FBI not relevant? Now, he says she wasn't reporting on Proud Boys. And that's not true at all, as we saw from this article. She actually said that specifically. Says that while Lowe maintained that while she provided the government information about some of the defendants before the trial began, her interest was still genuine. So that's just not accurate, right? She actually did give them information, according to the New York Times. Now, this judge has already made his decision. We didn't get an evidentiary hearing. We didn't get the government to give us the full file. What does the informant file say? What did she give you? You say you didn't ask for it. You say you didn't task her to do it. But what did she get you regardless? The judge says, no, she wasn't reporting on the Proud Boys. Yes, she was. So he just parlays that and he says, therefore, there's no good faith basis to ask her questions suggesting any impropriety by the FBI. You don't think an FBI informant in your attorney meetings with you and your client, I think that is improper. I think it's unethical. I think it's reprehensible. But the judge says it's not a good faith basis. And you can see, I think that everything he's doing here is legally justifiable. He's not breaking any rules. He's not doing anything that is even probably reversible. Maybe some of this is. I don't know exactly what's going on in court. But he has the authority to make these decisions. Say, yeah, it's not relevant. This is only about these very specific charges. And it's only about the conspiracy between these 5 guys, and anything else about other informants or what the FBI really thought about this I mean, this is all relevant to the other portions of evidence that have been dripped out. Remember, we had the spreadsheet where they talked about having just enough to get over the hurdle to not make themselves look like fools by prosecuting these guys. Is this enough? Can we get over the conspiracy charge? All of this talk about CHSs and informants would shatter that argument. It would say the FBI, their own informants, weren't even aware of a conspiracy. But the judge won't let him talk about it.
Judge Kelly, who is a Trump-appointed judicial officer, by the way, just in case anybody's wondering that. Trump put him in there, which is probably why they have him doing this case. He will not allow the defense counsel to ask this witness that they were going to call about her interactions with the FBI. Not important for this case. The FBI already said that they didn't use any of her information. Yeah, well, they also said that they gave us all the material that they obviously didn't disclose. Once a liar, always a liar. I don't even know how many times the government has been caught lying in this case. I am just hoping and praying that the jury kind of sees through this. Because there are things that have been put on the record that would make you question whether this was legitimate, like the number of confidential human sources there are, outnumber the number of defendants there are. That would make me go, well, why didn't the confidential human sources just vote against the defendant not to have this plan? Seems like a logical explanation to me. But we don't know, and we don't know because this is a politically motivated criminal charge that they are charging people. That's what it is. And Robert is like, I don't even see if you could get this overturned or not. I don't even see anything legally wrong with this because we don't have a justice system anymore. It's just legal. He has the legal authority to do these things. And that's incredibly heartening to me. Strikes my heart. And this is why I'm saying everyday normal people of America, lawyers and judges and attorneys cannot fix this. Because Alan Dershowitz doesn't even see that the rule of law is fully gone yet. Robert, my man who's reporting on this, says he doesn't see a problem with what the judge is doing outside of his own morals and beliefs. But what about this, people? What about the defendant's right to be fully heard? What about the defendant's right to say whatever they wish to say, to ask whatever questions they wish to ask? What about their right to be fully heard? You're saying that that's not being impeded on by not allowing the defense to ask questions of this informant? Is that what you're saying? And you remember how the media, they hopped in on this, saying, hey, give us access to the court. And of course, the court granted them access for that one thing. I just found out last night, the court has sealed another hearing again, would not give the media access, even though they were begging. I just didn't have time to put it in here. But let's look at what the media wrote. And to be fair, just to be fair, they did this in a different article. It is not the article talking about the confidential human source. But it was after all of that was known. It was after the confidential human source was known. And in my opinion, this is a complete propaganda piece. Inside the FBI's Jan 6 investigation of the Proud Boys, a log of messages shows how agents scrambled after evidence and sought to recruit members of the group, all while trying to squeeze in workouts and cope with the Bureau's obsolete technology. Is it bad I almost kind of feel bad for Pizzola? The agent, Nicole Miller, asked one of her colleagues. And after one of the colleagues responds, he did it to himself. "Oh, I know," she wrote. "His decisions put him where he is. Just feel for his kids. Wonder if he is going to cooperate, though." On cross-examination, the men's lawyers sought to use the log to suggest that other agents who chatted with Agent Miller had committed offenses like destroying evidence or scrutinizing emails between one of the defendants and his lawyers in a violation of the attorney-client privilege. A lawyer for Mr. Pizzola described the messages as evidence of a massive trail of FBI corruption. But Judge Timothy J. Kelly, who was presiding at the trial, blasted that assertion, saying it was unfounded speculation that has no place in a courtroom. "Help," a colleague wrote to Agent Miller in July. The team found solace where they could. Colleagues often asked Agent Miller if they could come visit her dog. Others talked about the distractions to be found in Mexican food and the TV show Ted Lasso. In October, in a punchy exchange, one of Agent Miller's colleagues said she had been listening to Mr. Real fighting with his wife, presumably on a monitored jailhouse line. Agent Miller wondered if the jailed Proud Boy had discovered his wife was cheating on him, prompting the colleague to write, "Ha ha ha, I'll bring the beer." In the same conversation, the other agent said she had read a series of emails between Mr. Real and his lawyer, at the time Jonathan Mosley. The messages indicated that Mr. Real was planning to fight his charges at trial, a fact that the other agent asked Agent Miller not to reveal to the prosecutor on the case, lest they freak out. Mr. Real's current lawyer, Carmen Hernandez, has accused the FBI of violating her client's rights by illegally looking at privileged communications with his former lawyer. Prosecutors say Mr. Real had used a jailhouse email system that clearly stated that all of its messages were monitored just like the phone lines, a measure they say that amounted to a waiver of attorney-client privilege. The conspiracy hurdle. Something else was on the phone, she said, a plan that Mr. Tarrio and one of his girlfriends had worked on. That appeared to be a reference to a document called 1776 Returns, which contained a detailed plan to surveil and storm government buildings around the Capitol on January 6. After calling Mr. Tarrio an idiot for leaving such material on his phone, Agent Miller's colleagues asked if the newly discovered information would get us over the hurdle of the conspiracy charge. A final break. There was one more big break. 2 days after Mr. Tarrio was charged, one of Agent Miller's colleagues wrote to say that a lawyer for Jeremy Bertino, a Proud Boy from North Carolina, had reached out suggesting that his client was interested in talking to investigators. The FBI had executed a search warrant at Mr. Bertino's home the day before Mr. Tarrio's arrest and discovered 3 AR-15 style rifles and a shotgun hidden behind a wall in the basement. "We can't make this stuff up," Agent Miller wrote. Over the next several weeks, Mr. Bertino was interviewed at least 3 times by prosecutors working on the case, and in October 2022 he formally pleaded guilty not only to a gun charge, but also to seditious conspiracy. In February, a few weeks before Agent Miller herself testified at the Proud Boys trial, Mr. Bertino took the stand as the government's star witness. Now, I just read that to kind of show you how the media spins things. Because if that's the way it really went down, why didn't they take it to open court? Why is the media telling you this story, but the judicial officer will not allow it to be said in open court? How come they'll say it not on oath, not under a penalty of perjury, out here in the public, but the judicial officer won't allow them to take the stand for an evidentiary hearing? What kind of sense does that make? What kind of sense does that make to you? This is the way that they report on it. This is the way that they report on it. And they even talk about them laughing at the Proud Boys. They even talk about Agent Miller feeling bad, at least for a moment. At least for a moment. You think that's a conscience? And my man Robert was saying that they just blatantly, openly gave this to the defense counsel because nobody cares. Honestly, what I think is that there's somebody in the FBI who still kind of has a little bit of a soul left, and maybe, just maybe, they hid all of those messages hoping that the defense would find them. Hoping that the defense would find them because they still have a little bit of their soul. Or maybe they don't have any of their soul and the creator just made them do it and they didn't even know they did it. I don't know. I don't know what happened, but what I do know is that it seems absolutely crazy. It seems absolutely insane that you wouldn't put that evidence in your case. All of those missing messages, if they were no big deal, why did you take them out? If they actually help prove your case, like they did in the newspaper article from the New York Times, then why didn't you leave them in and present them in court to the jury? That just doesn't make sense to me. And what's this 1776 document that they keep talking about? Let's check that out. Because it's a public court record. We can do those types of things. 1776 returns. You see the case number right up at the top where it's filed with the court. It tells you the contents. It has little circled areas like they were talking about in their messages. It has overall goals. Fill the buildings with patriots and communicate our demands. But obviously, they didn't talk about the Capitol building because they said that in the text messages. It has the targeted buildings, which the Capitol is not one of them. Let me tell you how sophisticated this plan is. Let's just look at the manpower needs. Here's their master plan for January 6th. They're going to have the leader, a covert sleeper, set up a fake appointment to get into the building and let other people inside. And just in case they discover that this is a fake appointment, they're going to have 2 people do that. And then you got to have the hype man, the one at the front of the crowd that leads the chants, maintains the energy and presence. You got to have the recruiter, the person charged with going and getting other patriots to come to the spot when they're required to be there. And the patriots that you're going to have at least a minimum of 50 for each building that you try to occupy. And what are they going to do when they are occupying the building? They're going to give them their list of demands. This is a lot like a sit-in or Occupy Wall Street, other known protests that have been completely legitimate, legal, and lawful. Let's see what their demands are. Here is their terroristic demands. Here we go. We the people. Our request is simple, constitutional, and non-negotiable. We demand a free and fair election. They demand that this election be done with paper ballots only, no electronic voting, no mail-in ballots, no absentee ballots, in person, with an ID, or no vote, monitored by the National Guard. They wish to have votes a lot like what was done in the Reconstruction of the South when we freed slaves. Have the National Guard watch over it. Have ballot boxes and paper. Make sure to identify everybody who comes to the polling booth. That's exactly what they did in the Reconstruction after the Civil War in this country. How is that criminal? How is that seditious? That sounds like they're promoting our system of government. They just wish for it to be administrated the way they would like for it to be administrated. And what's criminal about that? That's what the whole purpose of voting is for. That is why we choose and elect our administrators. And even with how bad our administrators are right now, even with how lawless it has all become, here's the number one reason why losing law right now is the scariest proposition that could ever happen in the history of humanity. Because if we lose law right now, right at the time artificial intelligence is making such leaps and bounds, you are very, very likely not to ever get law back. Because I've talked about it before on this channel. This is a spiritual war. It is a war for your heart, mind, and soul. Your soul, because it's spiritual. That's why in the ancient days, in the Tower of Babel, their temple, the center of society, they created the statues, the Baal, the bull statues, and they would judge you with a high priest. With the high priest. See, today we have the Capitol building, which means the temple to Jupiter in Rome, and they write statutes, no longer statues, no longer bulls of Baal, but they write statutes. They put a cross in between the U and the E and create another idol for people to worship, another law for people to worship and follow called a statute. And then they get the supreme being, a supreme being called a judge to apply it to you. And what happens when the Capitol, when the temple to the gods turns into an AI? Turns into an AI. And to talk about this with us, to kind of help us understand how scary this could be, we got Bill Gates talking about AI taking over jobs. But not teachers or doctors. We're going to keep them around until AI knows how to work with people just as well.
And ideally, within a contained domain, we'll get something that the accuracy is provably extremely high by limiting the areas that it works in and by having the training data and even perhaps some pre-checking, post-checking type logic that applies to that. You know, I definitely think areas like sales and service that there is a lot that can be done there, and that's super valuable. The notion that there is this emergent capability means that the push to try and scale up even higher, that'll be there. Now, what corpuses exist, you know, once you get past, you know, every piece of text and video, you know, are you synthetically generating things? And do you still see that, you know, improvement as you scale up? Obviously, that'll get pursued. And, you know, the fact that it costs billions of dollars to do that won't stand in the way of that going ahead in a very high-speed way. And then, you know, there's a lot of societal things of, okay, where can we push it in education? It's not that it'll just immediately understand student motivation or student cognition. There'll have to be a lot of training and embedding it in an environment where the adults are seeing the engagement of the student and seeing the motivation. And so even though you free up the teacher from a lot of things, that personal relationship piece, you're still going to want all the context coming out from those tutoring sessions to be visible and you know, help the dialogue that's there with the teacher or with the the patient. And so, Microsoft talks about making humans more productive. So some things will be automated, but many things will just be facilitated where the final engagement is very much a human, but a human who's able to get a lot more done than ever before around anywhere near that factory. So, a little bit people have saying, okay, these guys can overpredict, which that's certainly correct. But here's a case where, we underpredicted that natural language and the computer's ability to deal with that and how that affects white collar jobs, including sales, service, helping a doctor think through what to put in your health record. That I thought was many years off. And so all the AI books, even when they talk about things that might get a lot more productive, will turn out to be wrong. And because we're just at the start of this, you could almost call it a mania. Helpful. Now, he was reading that letter over to make sure it was right. In ChatGPT 4, we took the version 4 stuff, we took complex medical bills and we said, please explain this bill to me. What is this? And how does it relate to my insurance policy? And it was so incredibly helpful at being able to do that. Explaining concepts in a more simpler form, it's very, very helpful at that. And so there's going to be a lot of tasks where there's just huge increased productivity, including a lot of documents, payables, accounts receivables. Just take the health system alone. There's a lot of documents that now software will be able to characterize them very effectively.
Yeah. So one of the other things that I wanted to chat with you about.
AI is just going to make humans more productive. But we still got to have teachers and lawyers. But anybody, if your job is in the service or sales industry, it's gone. AI is going to take it over because that's what it's really, really, really good at. So if you were in marketing, sales, stocks, bonds, anything to do with calculations, service, building, all of those jobs are going to be gone. If they are not all gone, they are going to be very, very much reduced. Very, very much reduced. Just like the teachers. Well, they're going to make the teachers more efficient, but they have to keep them around to interact with the students, kind of like the doctors. People wish to have an actual man or a woman that they can talk to. These machines just aren't going to cut it until they can read your emotions that well. And Bill Gates couldn't foresee, he had no clue how quick the AI was going to start taking all of the white-collar jobs. How are people going to work? How are people going to sustain themselves with the living when AI comes around? And what is this AI really, really good at doing? It's good at explaining to people administrative things like their hospital bills, which is really, really good because hospital bills are the biggest reason of debt in the United States.
Welcome back to CBS This Morning. A recent study shows debt from medical care has skyrocketed in the United States. More than half of all the bills in collection right now are medical bills. That means debt collectors have gotten involved. Our consumer investigative correspondent, Anna Werner, has been looking into this and joins us now. Anna, what have you learned so far?
The biggest reason of debt. This is all going to move to administration, all of it. I remember reading an article from Bill Gates talking about how in 2028, 95 to 98% of all jobs in society will be gone. He said in this article that I can't find anymore, and it's probably because he said these things. He said People think when I'm talking about this that I just mean the labor force, the service industry, restaurants, McDonald's, Walmart, things like that. But I mean lawyers, accountants, politicians. It's all going to administrative. And because this is a spiritual war, because this is a spiritual fight, we have to do it to each other. We have to do these things to ourselves. That's why we have juries. That's why we have trial by juries. That's why we have grand juries to give the government permission to go after one of us. Because we were supposed to create this monster called government, but our creation has kind of gotten out of control. Over in Colorado, which I was at the beginning of January, where they didn't have any of the 3 search warrants on the record when they started the case, kind of making it to where they didn't have any foundation, legal foundation, for any of the evidence that they presented in court. Move forward with it anyways. They couldn't find anything. They couldn't find any case law that was real clear about you have to put warrants on the record of the court. They have to be stamped in by the clerk. They have to be signed by a judicial officer. They have to appear in the record of the courts. And this is a very, very interesting thing to keep sight of, because out of all the legal experts that I've seen break down Donald Trump's indictment, not one of them have brought up, mentioned to the fact that there's no clerk stamp on it, the DA doesn't sign it, the 4 men of the jury, of the grand jury, doesn't sign it. The only thing that I have seen has been a PDF document I could write up on Google Docs. And that is the proof to the public that Donald Trump has a good indictment. And I have not seen one legal expert notice that. Not one. That's scary. That's scary. That's where it's going. Why couldn't an AI just administrate all of those things? All we gotta do is get the grand jury out of the way. And over in Colorado right now, to my surprise, you don't have to have a grand jury indict you for anything for them to charge you with a felony. Not at all. Some counties don't even have grand juries. I don't know why others do. If you don't have to have it, if the government doesn't require it, they're just wasting people's time, I guess. That's incredibly scary, because you should have the right to be fully informed of the nature and the charge of the accusation, the nature of the wrong, and the cause of the accusation. That's why, while we're still talking about rights, I'm still pushing, especially after seeing the indictment against Donald Trump. He should go for a fast and speedy trial. I looked it up last night. If he moved for a fast and speedy trial, by their rules, they'd have to do it within 6 months, which would mean his trial would be around October, giving him plenty of time to go and campaign after that. Go in to the Republican primaries. That would seem like the good strategy I would use if I were him, and I would be happy to cover it, because we're not going to get cameras into courtrooms anymore. They're shutting that down. They're shutting any recording devices down. I saw somebody go to jail for having a recording device in court the other day. So much for free and open courts. They'll even decide when to shut the media out. They've already done it. They have already done it. And just think about this case. This is why everybody should be demanding that it's fast and speedy and public and on TV, because just think about the show that would be. This has all the hallmarks of an awesome case. You got an ex-president, you got an adult film actress, you got a Playboy playmate, you got crooked attorneys, political corruption. Could you think of a TV show that would be more entertaining than that right now? Could you think of one? I doubt Ted Lasso's that entertaining. And I find it really interesting. They're talking about Ted Lasso, and the same paragraph, they're talking about agents coming over to visit Miller's dog, Lassie. This stuff even sounds fake. It sounds fake. When was the last time your good friend came over to see your dog? Just tell me that. Just tell me that. Now, at the beginning I was talking about I was going to read some of the mandamus that Joni and I filed with the Fourth Circuit Federal Court. So for anybody who doesn't actually know what's going on in this case, let me just fill you in on some backstory. Joni and I had suspected that North Carolina Henderson County Court was going to violate Joni's rights, wrongfully throw her in a cage so that they could take her family's money away from her family. So we filed a notice with the federal court saying, hey, this might happen because when I was in jail, they wouldn't let anybody move documents on my behalf because they said they didn't know if I actually gave them authority to do it. Never mind the fact that Joni, who is a registered pastor, couldn't get in to see me as my pastor, as my spiritual guidance, having much of the same type of privileges that attorneys and clients are supposed to have. And let me tell you something about anybody who agrees, well, they hit that button to say that their communications were going to be monitored. They acknowledged that. That applies to attorney-client confidentiality too. There was no way to have a conversation with anybody when I was in jail, face-to-face. They have electronic monitoring. Somebody who comes in to visit you, they have to call you on an electronically monitored phone that has a camera on it. They can monitor that. They can monitor your emails. They can monitor your phone calls. We don't have privilege anymore. We do not have that privilege. We don't even have the religious privilege. Joni couldn't get in there as my religious advisor, even though she is a licensed, certified pastor. Think about that, Christians, Jews, anybody who's Islamic. You don't have freedom of religious belief anymore. The main way that I got law upheld in a courtroom for people was because they would go in there and say, I got a trust between me and my Creator. And that trust says, you got to give me my son or daughter back because my son or daughter ain't yours to take. You're coming in between a trust between the Creator and I, and you don't have any jurisdiction to do that. Think about that. Think about that. Because you can use that a lot of different ways. A lot of different ways. We go to the federal court kicks us out. Not only do they kick us out, they punish us. They punish us for even going and filing a notice like, hey, these criminals down here are about to break some laws. You know what? You guys can't file that anymore because you think that courts are criminal and they're going to break laws. Yeah, they kind of did. So we go to the appeals court with the mandamus. The court has a duty and an obligation to provide you a court of law. That's kind of the whole reasons why they exist. This comes from the mandamus. I'm going to read it to you real quick. To deny suitors action and declaration for moving forward would say people do not have right to ask for performance from government officers or accuse such officers of RICO-like conspiracy and move jury for verdict. Should Court of Appeals not issue mandamus or certiorari, all I ask is that said court explain in law so I may understand Every time court moves against law, it is almost never done with reason, logic, philosophy, or law. In my experience, it is an administrative rule only attorneys would know, or some are not possible to perform, as both of my recent appeals were dismissed technically for untimely filing, which must be done within 10 days from court sentence. First appeal, I was in jail for over 2 weeks and less than 3 weeks, but still much more than 10 days. The second appeal, I had to serve myself court documents and to this day cannot find any judgment or court process to speak of. So please use logic, common sense, and law to explain in clear and precise manner as to why suitors are not actionable and how, in law, it is legal for certain persons of status to take from people of lesser status, and where those lines are drawn. Please explain at what point of status which crimes are allowed and upon who. In my study of good civil government, this is the job of courts, to explain right from wrong and how that works. That's all I'm asking. If you're going to deny this, give me the reasons in law. Show me philosophy that defeats my philosophy. I will be a man and say, yeah, got a point there. You know, those laws are better. I'm surprised I never thought of them first. And here's the relief that we are seeking. The only relief Joni and myself are seeking is Joni and John seek review from Court of Appeals of motion to amend and refile on declaration of abduction and suitor's action and declaration for any errors of law incorporating declaration for mandamus, this document, incorporate the facts of this document into those other documents and the facts that are there, and let us know whether we are actionable in law, which the appellate court has done numerous times before. You can go read a lot of appeals about it. And declare if facts give rise to cause of action, and declare for district court and suitors if action may be common trust with court personnel acting as trustees who must furnish bonds. Should court find law and facts actionable, John and Joni wish mandamus and or certiorari issue to Martin Riedinger and command Martin rescind August 16 and September 26 orders and judgment, grant said motion in action, produce court of law, and ensure said court moves until agreement, settlement, or jury finds facts of accusations made either true or false. All we're asking is that you order the court produces the court of law. That is all we ask for, because we have accusations accusing these people that we wish to hold accountable of doing RICO-like conspiracies. We have at least 100 pages that we gave you, documenting step by step, including audio recordings of them saying that we will never get a court of law, our case. So if our case is flawed in some type of way, in any type of way, just tell us how it's flawed. Just tell us how it's flawed. Plus, make it really, really clear for everybody, for the suitors, for the judicial officer, for the courthouse personnel. Does the public have trust in the courthouse and our court employees when we put together a suit and we form it into a common law trust and give it to court employees to act as trustees? Do they have a duty and an obligation to act as a trustee to that lawsuit for the public's benefit? To have a court of law for the public's benefit. And they don't answer any of this stuff. Let me read to you what they said. Mandamus relief is a drastic remedy and should be used only in extraordinary circumstances. Further, mandamus relief is available only when the petitioner has a clear right to the relief sought. Mandamus may not be used as a substitute for an appeal. They don't explain it. They don't say, no, there's this case law saying that the clerks can actually tell you that you're never going to see a courtroom again, that they're never going to do anything that looks like a court for you again. And they couldn't say that because that case law doesn't exist. They didn't sit there and say, they actually have the right to beat you up and steal your property because that's a duty and function of government, so they have immunity from you suing them. They didn't say that because that case law doesn't exist. They didn't say, you know what? Your theories and your understanding of law is elementary, and here's how. Don't bother us anymore. And they didn't say that because that doesn't exist. The only thing they say is that a mandamus requires an extraordinary circumstance. The only way I can interpret that is you're saying not having a court of law is not extraordinary of enough of a circumstance for the Fourth Circuit Appellate Court to order a court of law? What was the other thing they said? They said a mandamus only gets issued when there is a clear ministerial duty to perform. The only way I can interpret that is judicial officers don't have a clear ministerial duty to maintain a court of law and to move under the rules of law in court. Clerks don't have a clear ministerial duty, and all a clerk's duty is ministerial, to provide a court of law to you, to summons a judge, to summons the other side, to make sure you have your right to a jury. You're telling us that these things are not ministerial and they have no duty to perform them. And I agree, mandamus is an appeal, but I don't have time to get into all of that right now. I'm just going to ask you this. If they aren't supposed to produce those things like a court of law and due process and all of that good jazz, why do they exist? What's the purpose of having courts without law? Except to control you, administrate you, take your property, make sure that you don't have any rights anymore. Put in a system that looks very, very close to communism without any law. And these are the things that we value in society. And let me tell you how I know for a fact that we value them, no exceptions. And that is because all of those people that I just talked about get paid very, very well. They all drive nice cars. They all live in nice houses. I don't even have the money to do these videos anymore. I don't have the money to have the hard drive space that I gotta have to save these videos and productions. I don't have the money to have the office supplies I gotta have to write down my thoughts to put this stuff together. We're not even gonna talk about trying to take care of my child. I spent all of his Christmas money trying to make sure that the courts would do the right thing and uphold law. Apparently they won't, and they won't even tell me why they won't do it. Nobody in our society, or very few people, because I would like to make a shout out to the people who do donate, and they donate enough, because we've had a conversation about it, to where I'm going to be making these videos until October. And after October, if people do not value this service that I perform in society, I'm going to have to quit. There will be no way for me to continue. It is not possible. And it's an incredibly scary proposition because this is the only way that any of us make it through to the other side. If we do not get law back, your life is going to look like hell and resemble hell very, very shortly. There is no other way for that to go. There is no other way for that to go. We value law so little that the attorneys who do get paid to perform it or to practice it cannot pull it off anymore. I have talked for years about exercising your common law rights in a court. I'm going to tell you right now, I'm not going to help anybody do that from here on out because it is dangerous. It is hurting people. The courts are hurting people more just for believing they have rights and nothing else. So for all of the Republicans out there who are really hollering and screaming about the injustice that's being done to Donald Trump, I don't care to hear about it until you make sure Republican-held jurisdictions like the one I'm in right now, like the one that locked me up for not driving when I did not know that they took away my license because nobody informed me. When you get them acting lawfully, then we can talk about Trump and how much of a travesty it is. But until Republicans uphold law, I don't really care to hear about the law being broken against you when you don't even care about upholding law in the first place. That sounds just as weak as the other side. It sounds just as weak as the other side. Oh, it's only criminal when you do it to us. It's not criminal when we do it to you. That's what has gotten us in this mess. Just think about it. Most Americans vote in a way to take away their fellow Americans' rights. Let's talk about just two huge issues. This is what we value when we go and we elect our administrators to administrate everybody. We look at, do they support abortion? Do they support abortion? We can't allow people to exercise a right to abortion because it's murder. It's murder of the unborn baby. You have the right to have that opinion. Absolutely. And then what does the other side, what do they call for? We can't let people have guns. We have to go after firearms because they murder people. They murder already born and adult babies. They murder already born babies who are in school. You see that? And just tell me, if you, on the right, have the moral and ethical right to take away the left thinking that they have a right to abortion, then why don't they have the moral and ethical right to take away your right to have a firearm that could kill somebody? How do we know you're going to use it responsibly? And until Americans start voting, start putting their energy, start putting their values into upholding each other's rights, until they do those things, and as long as they vote solely down the line of taking away their enemies' rights, their opponents' rights, the other side's rights, life isn't going to get better. It's only going to get worse. Because those are the things that we value. Those are the things that we value. I don't believe that this war, that this spiritual war is going to end the same way for everybody. Personally, I believe that the soul individuals, everybody individually who has their own soul, if they follow and perform law in this life, then they will probably escape the judgment that comes attached to law. And if they do not perform and follow law in this life, if they allow the world of the insane, to keep enraging itself out of control with no rights for anybody, then they're going to await the judgment that they have judged others with. Because that is the law that is applied to you. Is the same law, the same judgment that you apply to other people. And if you escape judgment, I believe that there is a safer time just right over the hill. If we actually got people interested in law and we could share this idea, spread this idea, and everybody upheld the principles of rights and justice, I believe we could turn this entire nation around to stand for truth, to have courts that are open and free to the public, to move in a productive way for our children's futures within a couple of years. It's not that hard, it's just all of the safeguards of law have been taken away. We are just conspiracy and we just wish to conspire to bring heaven down to earth. One world, love, and peace.